if you're employees, can I get a show of hand? Employers? You're an employer? All employers? You're also an employer. Okay, awesome. Right. I think there's two fundamental principles that you need to understand in order to avoid ending up at the CCMA. And that is that every aspect that you deal with has got a procedural leg and a substantive leg. So there you can see the two different legs, and I'm going to go into detail as to what each leg is about. And you need to make sure that you comply with both legs in order to ensure that any action that you take, you can defend quite confidently at the CCMA. So the substantive leg is the first one, and that is the reason that you are in dispute with your employee. What is it that's actually gone wrong? Is it the fact that they are absent from work? Is it the fact that they're insubordinate? Is it the fact that they're not performing to the standard that's required? Or is it the fact that you need to retrench because you have run upon difficult times? So that's the substantive leg. Then we're talking about the procedural leg. Regardless of which process it is that you're embarking upon, there's always a procedural leg that has to be satisfied as well. You have to make sure that you follow the correct procedure. There is always a procedure to be followed. Now, the most fundamental mistake that employers make is that they do not give employees an opportunity to say their say. It is the most critical part of making sure that you have a strong claim at the CCMA, is to make sure that you've given your employee an opportunity to say what they want to say. In Latin terms called the audi alteram partem rule. Quite simply, hear the other side. All right, so now I'm going to just quickly get into exactly what the different components are, the different categories that law, that the labor law issues that arise most commonly. So the first one has got to do with conduct, which deals with things like insubordination, absenteeism, gross negligence, or late coming. Those are issues of conduct. Then you move into the category of capacity, and that is issues of poor work performance. So in other words, an employee that's not able to meet the required standard, or they're unable to perform the job that they're employed to do because of ill health or injury. The third category is a retrenchment, otherwise known as operational requirements. Now, what I'm going to do is I'm going to just ask you if you understand the difference now between what's conduct and what's capacity. So are you clear that you know what conduct is and you're clear what capacity is? Yes? Everyone understands the difference? All right. So now what I'm going to do is I'm going to give you a scenario over here. And this is from actual case law, where it just shows you how quickly the lines get blurred between conduct and capacity, and how quickly you can land yourself into seriously deep, hot water at the CCMA. So here are the facts of the case. An employee was required to measure all samples, and depending on the results, the company would then mine in a certain area. The measurements that were performed by the employee were not accurately done, and the employee was charged with gross negligence and failure to work according to the applicable standards. So now the question is, because you understand now the difference between conduct and capacity, what would you say the issue here is? Is it conduct or is it capacity? The employee was asked to measure all samples, he didn't measure accurately, and he was charged with gross negligence and failing to work according to applicable standards. What was it? Was it conduct or is it capacity? Capacity. Capacity? Have a guess? Capacity? Conduct? At the back there, you guys, what do you think? Conduct or capacity? Both capacity. Okay, so who said conduct? So the two of you are right. So the question is, why is it conduct and not capacity? Because you're saying, well, hang on a second, this guy didn't actually measure according to the standard that's required. And what the court decided, and it started at the CCMA, then it went to the Labour Court, and then it even went as high as the Labour Appeal Court, because they struggled with a question just as much as you have. And what was the question here? The question was, listen, did the guy actually know how to perform his job and just didn't? or didn't he know how to perform the job at all? And the court found that because he knew how to do the job, on that particular day in question, he didn't actually do the job properly. So it wasn't that he didn't know what was required of him and he didn't know what the standard was. He did. He just didn't do it. So it was actually dealt with as a conduct, not as a capacity. The employee, as it turns out, was dismissed on the basis of incapacity, but it turned out that it was the incorrect classification because it should have been conduct. All right, so that's how easily it's confused. Let's have a look at another one. A manageress was confronted by the managing director of the company, and the manageress started shouting and screaming and was charged with gross insubordination. Would that be a fair dismissal or an unfair dismissal for that particular incident? Say again? All right, so the response was it depends how the MD actually approached. So let's say the MD approached very politely, very nicely, and the manageress started shouting and screaming, and the employee was charged with gross insubordination. Would it be a fair dismissal for gross insubordination? Come, you guys are the employers. You've got a situation on your hands here. You're the owner. You go and speak to an employee, and they start shouting and screaming at you, and you charge them with gross insubordination. What do you say? Would it be fair to dismiss for gross insubordination in those circumstances?
Unfair.
Unfair? Why unfair?
Because I thought maybe it was the first time that it could have happened, and you don't know what's the reason, for the person to just burst out.
Okay, anybody else? Anyone else got a view as to what it should be?
Fair.
Fair? Fair?
Yes.
I think it's unfair.
Unfair. You guys at the back. Unfair. Why unfair? You can't just say unfair and not motivate. You've got to give me a reason.
Because you don't really know the circumstances.
Okay. So, I mean, she's shouting and screaming. Are you an employer?
Yes, I am.
Okay. So you got an employee that you go and say, listen, I've got a bit of an issue with some of the stuff that you're doing with my employees. And she starts mouthing and shouting and screaming at you.
Yeah, but you also need to look at the history of that employee.
In what regard?
Regarding written notices, final written notices,
Okay.
stuff like that, yes.
Okay. So let's say that she has got written notices. Can you then dismiss her for gross insubordination?
If she already had a final written notice, most probably yes.
Okay, who agrees with that? Come on. You guys are non-committed. Come on, let's talk. You agree with that, with what he said, or you don't agree? You agree. You also agree?
Yes, I do.
You do agree. Okay. Who disagrees? None of you. All right, well, you're all wrong. Okay, so here's the important thing. And this is how badly and how quickly things go wrong in terms of a case. Because let's just have a look at this again. So I've said a manageress was confronted by the MD, and the manageress started shouting and screaming and was charged with gross insubordination. If you are shouting and screaming at your managing director, is that gross insubordination? Yes? No? Who says yes? Who says it's yes, it's gross insubordination? Who says no? Who doesn't know? Who doesn't care? Okay, it's not gross insubordination, it's gross insolence. Now, this is a case that also went all the way to the Labour Appeal Court, because the company charged the employee with gross insubordination, and it's not gross insubordination. Insubordination is failing to follow an instruction. It's not being rude or cheeky or insolent. So to charge somebody for gross insubordination when they're being cheeky is wrong. They're not being grossly insubordinate. They're not failing to follow an instruction. They're being rude or insolent or cheeky. So it's important to make sure that you categorize it correctly. Because if you put the wrong thing in, you've got a problem. Okay, are you guys warming up? Can we do another one? Are you kind of getting into it now? Let's have a look at this one. Now this case is hot off the press. This is a judgment that was handed down 3 weeks ago. So it's brand new law, and it's very interesting and very important law. So let's have a look at it. Let's get the opinion of all the judges here in the audience. So an employee was given notice to attend a hearing. for being absent without permission, and gross insolence, here it is, in that he turned his back and walked away while his manager was talking to him about his absence. At the hearing, the employee raised the defense that he was suffering from depression. So the allegation is that you're attending a hearing for conduct, because you all told me that you know what conduct is now. So an employee was given notice to attend a hearing for being absent without permission, and gross insolence in that he turned his back and walked away while his manager was talking to him about his absence. At the hearing, the employee says, I'm suffering from depression. Do you deal with it as conduct, or you deal with it as capacity? Capacity. Conduct. Conduct. Capacity. Either. Both. Come on, guys. You're sitting as the disciplinary chairperson for one of your employees, and they say, listen, here's the story. I know that I walked away I turned my back on my manager while he was talking to me, but I'm suffering from depression. So that's my explanation for doing what I did. Is it a good enough explanation? It can be.
I'm just looking at it because in terms of capacity, the worker is not able to do their job properly. I'm looking at the way that was said. That was not when the manager was talking to him. The manager was confronting him about the situation while not in a formal disciplinary environment.
Yes.
Because he was like just standing in the passageway in front of other staff members, which is unacceptable.
Where does it say that?
No, because they said they were standing talking. They weren't sitting in an office private.
Okay, let's complicate it for you. Let's say that they were standing in an office talking, just the two of them. No one else was there. Let's just complicate things for you a little bit.
I don't know all the situation.
It was done very politely, very professionally,
Okay, yeah.
very confidentially.
If the manager was aware of the depression, had he taken any steps to actually aid the employee in this situation? That would be my question. I don't know everything.
Okay. So are we saying that if you raise the defense of depression to the fact that you were rude to your manager, that is a good enough defense? Oh, now you guys are scared to answer. Eh? The guys at the back. You were very confident to start off with. Now you're a little bit doubtful. Come on, let's hear it.
I will still say capacity.
You'll still say capacity.
Yes.
Why?
Because depression is a medical condition,
Yes.
and then if your employee didn't raise that before the hearing, it means that the position that he has been appointed to cannot be performed according to the job description. So that's why I will say incapacity.
Who agrees with that? It's the right answer. Give that man a bell. Have you got? It's the right answer. Ultimately, what the disciplinary chairperson decided is that, listen, I'm not here to chair a hearing in regard to depression. The issue was conduct. You behaved poorly, and I'm now here to hear a disciplinary hearing in regard to the allegations against you. And the judge said that the disciplinary chairperson was incorrect. That what they should have done is they should have actually understood and listened to what the employee was saying in regard to depression, and that it was a very compelling reason for the behavior that the employee exhibited. So in other words, it was because they were depressed that they behaved the way they did. It wasn't as if they behaved ordinarily in that manner, but because their depression kind of overtook the manner in which they were behaving, that was something that was very important from the judge's perspective. And it is something, it's a judgment which you're not going to find anywhere in our labor law. It's groundbreaking, this, and it's going to become more and more prevalent because of the interest that's been shown in this judgment. I posted an article on LinkedIn in regard to this, and in 2 days I had over 1,000 people read this particular publication. So it's obviously something that's going to become very prevalent in the workplace, and it's something as employers that you need to be super aware of, because otherwise you're going to get punished pretty much like the employer in this instance did. Ironically, you can see that the employer was no other than Legal Aid South Africa. Quite ironic that they were the ones to get a hiding here. Just a bit of fun here. If an employee is frequently absent, habitually absent or persistently absent, and a medical certificate is produced each time. Now let's just say that the medical certificate is different on each occasion. It's not necessarily the same illness. So the one day it's a running nose, the next day it's a running stomach, the next day it's a sore toe, and the next day it's a sore back. Can you discipline an employee who is regularly absent, but even though they provide a medical certificate on each occasion? Yes. Where's that speaker? Don't you want to just give her the mic? Thanks so much. Don't be shy. Let's hear your views.
Yes, they do abuse their sick leave.
They do abuse
I
it.
have to check their sick note first before I do a misconduct.
So can you discipline them even though they've given you a medical certificate each time? It's from different doctors. It's not the same doctor. It's not some skebberich something going on there.
That is the problem.
Eh?
That is the problem. That's why I'm not sure.
You're not sure? All right. Who is sure? Yeah, let's hear it. You guys on the side, come and join in the fun here. Come and listen to us. Come and talk. Come and give your opinion. We want to hear what you think.
I would say that the company, the employee is abiding by the rules by providing the certificate. But I would say the other side open to the employees to say that they're not able to do their job anymore, which means that they could be boarded or say we can't employ you anymore because you have inability to do the functions which we employed you for. But in terms of the discipline, the employee is doing everything correctly. You can't discipline them for keeping the rules. They are keeping the rules.
Okay. Who agrees with that? The gent at the back, come and sit down and come and join the fun here. Come join us. We want to hear your view. There at the back, with a green top. You're just listening in. Okay. Let's hear. Who agrees with that? Do you guys agree with it?
I'm not quite sure.
You're not sure?
No.
Who is sure?
I'm not sure, but I would agree with
You're not sure that you agree? You agree that you're not sure?
the sentiment that it's not misconduct.
It's a problem we get all the time.
Yes, you can. You can discipline them. Here's a man with some conviction. Let's hear it.
Of course, it's not viable working for the company.
Yes.
If you are continuously sick,
Yes.
you're not adding your worth. I'm paying you X amount of money per month and I'm getting my worth out of it, and sorry, look for somebody else, look for something else.
Okay, so now who agrees with that? Because that's quite a different opinion. That's quite a different approach. He's saying, listen, as far as we're concerned, you can't actually employ somebody who's never at work. And you must discipline them, despite the fact that they're providing a sick note on each occasion. Yeah?
In my opinion, I think you cannot discipline the employee for misconduct.
Yes.
You as the HR manager can verify those medical certificates are correct.
Yes.
You as the company then can offer the employee to have a full medical done at your cost to ascertain the condition of this individual.
Okay, did you hear that I said that the one day it's a runny nose, the next day it's a runny stomach, the next day it's a sore toe, and the next day it's a sore back? It's not the same thing all the time. You're standing by it.
Stand by it. You still can do a complete medical at your cost to the company and then make a decision.
So now we've got two contrasting views. Let's have a show of hands here, because one of them's right. They can't both be right. So on the one hand, you've got somebody who says, listen, you can discipline the employer, a bigger part of the employee, because you're saying, listen, you guys are not actually helping because you're never at work. So I can't run a business without you at work. On the other hand, you've got somebody who's suffering from incapacity, who's provided legitimate medical certificates. Do you now say, well, listen, I've got to have some sympathy with the person who's ill. They're having a bad run, and it's unfortunate. I've got to just understand it. So which is it? That's A, and that's B. So let's see who supports A. 1, 2 of you. So the rest of you support B. Is that right? Yes. You've got to have sympathy, and you've got to understand. You can't discipline them. Okay, so A is right. You can discipline. And he's dancing a jig for us. Okay, so the bottom. Yes, there's a question. Do you want to pass the mic to them? I'm sorry. Yes, fire away, I'm listening.
Shouldn't I find out from the employee what's not motivating him or her to come to work?
Well, I suppose you can, but if the employee says, listen, there's nothing that's not motivating me, the problem is that I've got a sore stomach, I've got a sore nose, I've got a sore toe and a sore back. There's nothing wrong with my motivation. What do you do in that instance? The gentleman was right when he said that you're actually entitled to discipline somebody who's not regularly and sufficiently at work. Because you're employing that person, they're entitled to sick leave. But if they're continually absent, what are you employing them for? They're never at work. Yeah. Okay. So now let's do some more questions here. An employee must be given 3 warnings before they can be dismissed. True or false? True. False. 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 True. Who's now not sure? Yes. Now you guys really don't know. Now I don't see any hands at all. Well, I'll ask if it's true. No hands. False. It's no hands. False. Doesn't know. False. False.
Depends on your HR policy.
Must you give 3 warnings? Yes or no?
No.
No. Who says you must give at least 3 warnings? Why? Like baseball, 3 strikes first before you're out.
Even bosses and managers can't be there all the time. Don't do their job perfectly all the time. So if somebody made a mistake once, okay, you get a warning. You get another one, another like verbal warning or written warning. This is serious. 3rd one, bye-bye. So at least they've been given a chance.
Who agrees with those sentiments? No. Well, you're very unpopular here. Huh?
If the first transgression is theft, what do you do then?
So that's the counter question. The counter question was, what happens if it's theft? Must you warn somebody 3 times to not steal from you? Well, now you're not sure anymore.
Diamond ring.
No. There has to be a policy where in case of theft, 1 to 3, it's terminal. It's done. Because theft is just out of question. Bye-bye.
So no 3 warnings there. Say again?
If it's done once, it'll happen again.
So therefore,
bye-bye.
out on the first time?
Yes.
Quite right, 100%. Okay, here's another one. The retirement age of employees in South Africa is 65. True or false?
Depends. Male or female?
All right, you pick whichever one you want. Who does retire at 65, male or female?
Male.
Male, okay. Anybody agree or disagree or couldn't care? Huh? What do you say? Is the retirement age for employees 65? This is how you end up at the CCMA, because you dismiss somebody because they've turned 65. Well, is that a fair dismissal or is it an unfair dismissal for dismissing somebody at 65? Is 65 the retirement age in South Africa? Yes. Come on, guys, now have I bamboozled you? Now you're too
Why
smart
is
to
it in
answer.
your contract?
Huh?
That's correct, if it's in your contract.
Ah, who agrees with that? Only because I said, well, you're wrong. No, you're right. The fact of the matter is, if you haven't got a retirement age that's agreed with employees when they start, you then do not have a retirement age for that particular person. If you then go and dismiss somebody at the age of 65, you have then discriminated against them on the basis of age. Your case starts at the CCMA, ends up at the Labour Court, and you could end up paying an employee up to 2 years' worth of salary for discrimination.
What happens if you start with a company where there is no age in place, and in the sort of what you call the document with all the terms of employment,
yes,
their handbook, employee handbook, then change that and put that in? Are you still contractually? Must it still be contractually there, or can it be in the company sort of employment rules, whatever you want to say?
Can anybody answer that? I don't. I can't answer it. Can anybody answer it? Just kidding. Who knows the answer to that question? If you've got it, you know the answer. All right, let's hear the answer. Step into the ring.
Sorry. So basically, if you want to amend an employee's contract, that employee has to agree to that amendment. If that employee disagrees to the amendment, you have no leg to stand on because his initial contract will still be binding.
That's absolutely correct, but that doesn't really answer the question that was what you raised, because you're saying that if I understood you correctly, you're saying if there's a contract of employment in place and it doesn't provide for a retirement age, but the company policy outside of the contract of employment provides for a retirement age, does that then the company policy get read down into the contract? Do you want to take a shot at that now?
Isn't it unless the employee knows about it, that it's got to be brought to his attention before the time?
Okay. Any other guesses? Okay, so if you'll generally find the very last clause of the contract of employment is going to provide that all other terms and conditions and company policies, etc., form part of your contract of employment. So if that is the case, then definitely the policy that will regulate retirement age can be read down into the contract. In the absence of it, then the gent at the back there is right. Because if he's not aware that there is in fact a retirement age in place because that's company policy, it hasn't been drawn to his attention, then indeed you've got a problem.
Sorry, what often happens is
Carry on.
You've done your contract, everything else, there's a company policy in place, or there wasn't one in place. What then happens is 2 years later into your employment, they say, listen, by the way, retirement is now 60 and you're 59, and you go, do you have to object to it and say, sorry, that was not in my initial terms of policy because now they brought it in subsequent to your contractual agreement?
Can you do that? You guys are all the employers here. So now you want to say, listen, I want to start retiring people at 60 because they're over the hill already. And I never had a policy in place before they arrived. Can you now impose that retirement age? Can you do it? Who says you can? Shrug of the shoulders was the general consensus. Yeah? Pass him the microphone, please, if you don't mind.
Yes, you can, because before implementing a policy or procedures, you need to basically speak to all your employees, and if they all agree to that specific policy and procedures, then it can be implemented.
Right. So if you do it in consultation with your employees, you've got to say to them, listen, this term and condition of employment doesn't actually exist. Currently, it didn't exist at the time that you entered into the contract with us. However, we need to implement a retirement age, and this is what the proposed retirement age is. And on that basis, you can then amend it. If they disagree, then you're saying, well, listen, I didn't agree to that, and there's nothing you can do about it because there wasn't an agreed, because ultimately, what is a retirement age? A retirement age is an automatic termination of the contract when you reach that particular age. And you're saying, I never concluded my contract on that basis. I entered it on the basis that it was going to be forever. Now you're imposing a termination date on me and I'm not prepared to agree to it. So it's just too bad. That person will stay there until the day they die. It was a question you had.
With the new minimum wage coming into now, so that will be legislation basically. Your legislation will be saying that employees have to earn 20 Rand per hour. I think it's 20 Rand per hour.
Yes.
So how would you read that into your new contract? So you have employees obviously your employees not going to object to more money, but how do you protect yourself against it? Because maybe you're a company that can't afford 20 Rand an hour, and then you're going to have unfair dismissals because in order to meet that 20 Rand per hour, which will become legislation, you'll have to let some employees go. So how do you get around all of that? Because technically you still want to keep on employees because you're creating jobs, but on the other hand, you can't afford to pay those employees. So what do you do?
Anybody got any guesses? There's two questions. There's two questions that actually arise from that. The first is, what do you do in terms of the fact that you've now got to impose a term and condition of employment? In other words, this new rate, which didn't exist before, which has been imposed by way of legislation. And the second is, what happens if you can't actually afford it? So let's just deal with the first one first. Once it's imposed by legislation, it applies automatically. By virtue of law, it applies automatically. Pretty much like if you don't have a contract of employment with your staff, the Basic Conditions of Employment Act apply automatically. Whether you have a contract or whether you don't have a contract with your employees, the Basic Conditions of Employment Act, whatever's contained in that Basic Conditions of Employment. So if you say to an employee, listen, I didn't agree to give you leave before you started working for me, and I'm not giving you any leave. You can't do that, because the Basic Conditions of Employment stipulates exactly what is and isn't an entitlement. So in terms of the legislation, once that legislation is imposed, then that will be what the law is, and that is what the contract. It will automatically overtake the terms of the contract. So the second question was, what happens if you can't afford it? Now, it's something that's imminent, and it's something that's not yet regulated, but there are going to be regulations which apply where employers who cannot afford that minimum wage are going to be able to apply for exemption from it. But you're going to have to motivate as to why it is that you ought to be exempted from it. And you're going to have to do it in consultation with the employees and with any other trade union. If there's trade union representation present at the workplace, you're going to have to do it in conjunction with them. So the question is, what happens if you don't get that exemption granted and you can't afford to pay those wages? What do you then do? Phone Craig.
Shorter hours? Shorter hours?
What do? You can't afford it. What do you do? How are you going to impose it? The government has said to you, listen, the rate is now 20 Rand an hour. You can't afford those wages. What is it that you do? Do you have a disciplinary hearing and dismiss them for misconduct? No. Incapacity, they can't perform the job at the rate that you wanted. What do you do? Retrench. Can you retrench? Yep, you can. So let's go back here. We were dealing with, when we first started, we dealt with the substantive leg. The one in green is operational requirements, which is retrenchments. One of the grounds upon which you can retrench is economical reasons. So if you cannot afford that, and this is one of the fear factors that there are with the government, is that people are actually going to be losing their jobs, because companies are going to say, listen, we just simply cannot afford those rates, and the only way that we can deal with it is to reduce our workforce. So that's definitely on the cards, there's no question. All right.
Ask me a question.
Yes.
I'm a farmer. Yes, I am.
Okay.
I can't reduce staff altogether, but can I reduce on hours?
Yes,
so they'd be more productive in shorter hours?
Absolutely. In fact, the courts would actually love you for doing what you're doing, because what you're doing is you're not imposing the sanction of dismissal, but you're saying, well, listen, as an alternative to people losing their jobs, let me rather make it more viable and more manageable for the business, but at the same time not costing their people their jobs, because people would rather earn 1,000 Rand a month than earn nothing. So even though you're reducing their wage perhaps from 2,000 to 1,000, the courts would rather that you're having them earning 1,000 than earning nothing. So there's nothing wrong with that at all. However, what's very important, and it's something that I touched on earlier, is the procedural leg. You'll see that the procedural leg, if you look there, it requires consultation. It's very important that you consult with your employees. You don't just impose it upon them, but you consult with them. All right. Okay. All right, let's talk about disciplinary hearings. Can a colleague chair a disciplinary hearing for another employee? So can a co-employee chair, or must you get an independent chairperson? Yes. Yes, to both. There must be, you can have a chairperson who's independent, and you can have one who's a colleague. Either or. Anybody differ? Must you always appoint an independent chairperson to chair your inquiries? No, you don't need to. Does it make a difference if the chairperson has got prior knowledge of the proceedings that are the subject to the hearing? Yes. He can't chair the hearing. So if you've got prior knowledge of a matter that you're chairing, you happen to witness the altercation that you're now chairing, are you excluded as the disciplinary chairperson?
Yes.
You are?
Yeah.
You can't chair it. Why not?
Because according to the law, I'm not supposed to have prior information regarding the hearing.
Who agrees with that? Let's have a show of hands. Who disagrees? You're wrong. The law doesn't actually, it's preferable, but the law doesn't actually prescribe that you can't have prior knowledge. If you look, there's a schedule to the Labour Relations Act, Schedule 8. If you look at Schedule 8, it says there what must and mustn't happen in regard to a disciplinary hearing. And one of the requirements is not that you have to have somebody who doesn't have prior knowledge. Even though it's preferable, it's not compulsory.
Wouldn't they say that you are biased to the verdict?
If you would, let's say you happen to witness two employees having a fight, and you sitting as the disciplinary chairperson, how are you going to be biased by virtue of the fact that you witnessed the fight?
I can't be the chairperson as well as a witness.
But it's a company that has only 4 employees. You're the most senior. There's 3 other employees in you. Who's going to chair the inquiry?
Tricky question.
Tricky question?
Yes.
That's my job. My job is to ask and answer tricky questions.
Well, I will say, I will then rather subcontract someone else to chair the hearing.
Okay, fair enough. You wanted to ask a question?
I think when the person who chairs the hearing, all that's got to be done is that the judgment must be fair. He's got to take both sides of the case and say, this is what happened, that's what happens. If he makes a decision, it's got to be fair. You can't just say, well, I just feel this guy was guilty, therefore we're going to dismiss him. Because what's going to happen is if the guy takes it any further, they're going to look and say, is the judgment fair based on the evidence was provided? Pretty much that.
Yeah, quite right. 100% right. What about another issue that comes up all the time at the CCMA with employers is that of suspension. If you're going to have a disciplinary hearing for an employee, can you suspend them pending the disciplinary hearing? Yes or no? And the employers on this side are very quiet. Can you suspend an employee pending a disciplinary hearing? So the employee is stolen from you, let's say, and you're having the disciplinary hearing, but you actually want to suspend that employee, you don't want them on your premises. Can you suspend them pending the disciplinary hearing?
Yes, you must.
You must?
Yes, because you can't fire, if it's a dismissible offense, you must suspend the employee. Otherwise, it will be difficult to explain to that there was a breakdown in the trust relationship.
Do you suspend them with or without pay?
With pay. With pay.
You suspend them with pay. So now, you are the boss. You go and you say, listen, you are accused of having stolen from me, and I'm suspending you. And you hand him a letter of suspension, correct or incorrect?
Yeah, correct.
Correct.
Yeah, you hand him a suspension letter with pay and tell him out of the business while we finalizing the investigation.
Okay, who agrees with that? Who disagrees? That's great because you're all wrong.
No.
So this is how you end up getting problems at the CCMA. So what is the answer? What? You can see the shock. The bottom line is, I don't know if you were at the start of the talk, you might not have been, and I'll give you the benefit of the doubt for now. The golden rule. Audi alteram partem. Here the other side. If you suspend an employee, you have to give that employee an opportunity to say why they should not be suspended. You can't just present them with a letter of suspension and say, here it is, even though we're suspending you on pay, you are hereby suspended, here's your letter of suspension. You have to give them an opportunity and say why they shouldn't be suspended. You disagree?
No, I agree with you, but...
You've changed your mind?
No, I agree with you. Yes. But it's all in the fine lettering. In the reason, I mean, it doesn't matter what reason he gives you. If he gives you an unbelievable, fantastic reason, look, I wasn't even in the work at that stage. Obviously, it's a different ballgame, but you can still suspend him, and you must suspend him pending the investigation. Doesn't matter what you say, unless it's an unbelievable good and true.
Absolutely. Yeah. The important issue is that you've given the employee a chance to have their say. Whatever it is you're doing in the workplace, regardless. That's the golden rule. If you take nothing away with you today, but this, here the other side, just keep it. There's two legs there. You can see the two legs. The one is the reason why you're suspending the person, and the other is the procedure that you're following before you're suspending them. Always, always hear the other side. Always. Right. Are restraints of trade still enforceable in light of the Constitution, which gives you the right to practice your profession as you choose? Don't you want to just pass the mic, please? Thank you.
My friend recently got dismissed. He had an altercation with with the owner of the business, and his manager chaired the hearing. He has gone to CCMA since then, but that couldn't have been, in my opinion, I don't think that's very biased, because the manager can't go up against the boss. Can't, understand what I'm saying? Or what do you think in a situation like that?
Okay, so because what you're saying is essentially, why should an employee of the company find against the company because they themselves are an employee there?
Yep.
Yeah. In the green jacket, what's your comment to that now? Don't know. Fresh out of ideas. Anybody got any advances on this? No. So the fact of the matter is there's two issues that arise there. The first is whether your friend actually objected to the person who was chairing the inquiry at the start of the inquiry. What he should have done is he should have said, listen, I don't think that it's fair that you chair my inquiry. But just by virtue of the fact that he's an employee doesn't necessarily indicate that he's biased. It's not an automatic indication of bias. It might well be. But if he didn't lay a foundation for it at the start, you can't come and then complain afterwards when the decision has been made against you that you're saying, well, listen, you were actually biased against me. So it's important when you're in that particular instance that he needed to explain, listen, I'm objecting to you being the chairperson on the basis that I think that you're biased. The chairperson then would have had the opportunity to respond. And I get it all the time. Please believe me, I sit and chair disciplinary hearings, and the first thing that the employee says to me is, listen, you're here at the request of the employer and therefore you're biased. It's the automatic default position. Straight away you will, listen, you must be biased because you're here because of the employer. So I said, so then the only way that any chairperson will ever prove that they're not biased is if they find in your favor. Is that right? So if you were the employee and I said to you, you said to me, listen, you're biased. And I said to you, well, how do I demonstrate that I'm not biased? By finding that you're not guilty? Well, then give me that chance. Only then can you determine whether I'm biased or not. And you've got to have a basis for bias. You can't just automatically assume somebody is biased. You've got to give them an opportunity, and if they base it on fair and cogent and compelling reasons, you can't say that person is biased. It may be the only conclusion that anybody would have come to, even maybe your own mother, I don't know. let's just finish it, because I mean my time is up. Let's finish you off with an interesting one. What about restraints of trade? With the advent of the Constitution and that you've got the rights to freedom of your chosen profession, does that mean that restraints of trade are now not worth the paper they're written on? You can enforce a restraint of trade. Who says you can't? Not sure. Don't know. Fast asleep already. What does it mean? A restraint of trade? A restraint of trade is where you are limited. You sign a contract with your existing employer to say that for a particular time or for a particular period of time or in a particular geographical area that you won't then go and compete with that employer.
They're allowed to do because it's their income.
Who agrees with that? That the right of an employee to earn a living is more important than the right of an employer to protect its business. Which one's more important? The right of an employer to protect its business or the right of an employee to earn an income?
Unless if they sign a contract that states that they're not allowed to do it in a certain area.
Pass the gent the mic there.
The right of the employee to earn an income, I would say, takes preference.
Yeah. Who agrees with it? What is it? I didn't hear.
I had somebody who I had a product, and one of my employees went and they did similar thing, and I tried to restrict them and went to court, and yeah, they won.
They won. Do you know why though?
The guy said that it was his income and he had...
No, that's not why. You went to the wrong attorney.
I think so. What's the problem?
Okay, so the bottom line is that the Constitution doesn't necessarily trump a contract. So just because that somebody has the constitutional right to earn a living doesn't mean that whatever contract they sign is worth nothing any longer. The courts will weigh up and balance the interests of both parties. They will look at the interests that the employer is trying to protect. Are they trying to keep their customers? Is it confidential information, secret recipes? What is it that they're looking to protect against the employee's right to actually go and earn a living? And they will balance out those interests. You're nodding vociferously, which means you agree with what I said. So you did go to the wrong attorney.
It was a trademark that I tried to cover, and I lost it.
Just explain that.
I had a product on the market.
Yes.
And it was easy drape. It was a draping bracket, and he could change it slightly.
Yeah.
And he could carry on by changing the product a little bit.
Yeah. So instead of using hammer and nails, you use screws, and then it suddenly changes the trademark. Yeah. Whatever it was. Okay. I'm running over time here. Are there anybody with any other questions? Anything that you want? Anything that's topical? Anything that you need some insight on? No? We're good? Yes. All right. So thanks for listening to me. You're welcome. I've got some business cards here. You're welcome to take a business card with you. And if you need to, you can contact me either by telephone or by email. And you can just tell me that you were at the talk, and I'll help you with the greatest of pleasure. So thanks very much, and enjoy the rest of your day.